All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Bonjour à tous. Après 5 minutes, je souhaite à nouveau la bienvenue à tout le monde à l'intérieur et à l'extérieur de cette salle d'audience. Madame la greffière d'audience, veuillez annoncer l'affaire.
Good afternoon, Madam President, Your Honors. Situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121-0125. And for the record, we are in open session.
Merci beaucoup, Madame la greffière. Je vais maintenant demander aux parties et participants de se présenter, en commençant par Monsieur le procureur adjoint, mais il n'est pas là, je pense, le représentant du procureur, Monsieur Nichols. Puis-je vous demander de vous présenter et me confirmer la liste de vos collaborateurs que j'ai reçus avant l'audience exacte.
Yes, thank you, Your Honors. Same people.
Merci. Monsieur Kaufmann, à nouveau, vous voulez vous présenter et confirmer que la liste de votre collaborateur que j'ai reçue avant l'audience est exacte.
Indeed, Madam President, it's the same people, but I would just like to mention Mr. Davide Rancati, because I butchered his name so often up until now that I feel I have an obligation to say it properly. Thank you.
Merci, Maître Kaufmann. J'invite désormais les représentants légaux des victimes à se présenter et à me confirmer que la liste de collaborateurs que j'ai reçus avant l'audience exacte, Maître Messina.
Madame la Présidente, même composition que pendant l'audience de confirmation de charge. Merci.
Merci beaucoup. Quant à la Chambre, mes collègues à ma droite, c'est la juge Reine Adelaïde Sophie Alapini-Gansou et à ma gauche, la juge Maria del Socorro Flores Sierra. Et je m'appelle Julia Antonella Moto, et je suis la juge présidente de la Chambre préliminaire 1 de la Cour. Je rappelle que la présente audience est tenue en application de la règle 118, paragraphe 3 du règlement de procédure et des preuves, disposant d'une audience de réexamen de détention doit être tenue au moins une fois par an, à compléter la date de la première comparution du suspect qui a eu le 14 mars 2025. Cette audience est consacrée uniquement à examiner les circonstances justifiant le maintien en détention de M. Duterte au sens de l'article 58, paragraphe 1 du statut de Rome. Je rappelle aussi qu'un appel interjeté par la défense à l'encontre de la dernière décision de la Chambre, numéro 357, relative à la détention de M. Duterte, est toujours devant la Chambre d'appel. Par conséquent, les moyens soulevés dans cet appel et les réponses irrélatives y seront être répétés durant la présente audience. Je donne maintenant la parole à l'accusation. Vous avez 20 minutes.
Your Honor, I'll be much less than 20 minutes, just a couple minutes. And first, I would like to apologize if I interrupted you in the last session. I apologize for that, and it won't happen again. Just very quickly, Your Honors, I won't even go through the law, Your Honors. We've been through this before, but there have been, we would say, no change in circumstances that would require the Chamber, and it is under appeal to modify its decision. There has been a change in circumstances, I'll keep it very brief, Your Honors, which goes against granting interim release, which is the waiver that Mr. Duterte filed for the confirmation of charges hearing. In that waiver, he said, I do not recognize the jurisdiction of the International Criminal Court. He said that he was forcibly pushed into a jet and renditioned to The Hague. He refers to his arrest as a kidnapping. none of which sound as though those are the words of a person who would return voluntarily to the court. Mr. Kaufman had previously said in his pleadings, talking about if there was interim release to a third country, that Mr. Duterte would follow through video link. However, for this hearing, even though he's been granted a waiver, he also doesn't even want to follow from here. So that means if he was granted interim release and your honors had, as is within your power, ordered him to attend, it would have been very difficult to make that happen if he simply showed the same disrespect and did not wish to attend even through video link. That's all I have to say. Thank you.
Thank you very much, Mr. Nicholas. And I accept your apologies for interrupting me before. Nous pouvons maintenant désormais passer aux observations des représentants légaux de la victime. Vous avez 15 minutes. Maître Batayan.
Madam President, Your Honors, in behalf of the participating victims, we humbly submit that if there are recent developments that have an impact on this Chamber's review of Mr. Duterte's detention, they are developments that strongly support and fully warrant Mr. Duterte's continued detention. Let me discuss these recent developments, Your Honor. The first one was cited by the Honorable Prosecutor, which is the reason for the waiver that was signed by Mr. Duterte. With his very clear declaration that he does not recognize the jurisdiction of this court, and his insistent claim that he was kidnapped and illegally surrendered to this honorable court, Mr. Duterte has clearly demonstrated that he will abscond from the jurisdiction of this court if he is released from detention. Any condition the court will impose for his release will be considered by Mr. Duterte as non-binding, for the simple reason that he does not recognize this court's jurisdiction and that he is a victim of kidnapping. If Mr. Duterte cannot even hide his contempt for this honorable court while he is already under detention, imagine how Mr. Duterte will use this contempt for the court if he is released. Mr. Duterte has telegraphed his intention to escape from this honorable court's jurisdiction if he is released from detention. Consequently, Your Honors, he remains a flight risk if he is released from detention. The second recent development that is relevant on the issue at hand is the fact that more than 160,000 of Mr. Duterte's supporters submitted a letter petition to the Philippine Supreme Court, urging the issuance of a writ of habeas corpus as a means to force the return of Mr. Duterte back to the Philippines. The Supreme Court case seeks to declare the arrest and surrender of Mr. Duterte to the ICC as void and unconstitutional. This show of support proves the stark reality that if Mr. Duterte is released from detention, there is a huge risk that his supporters will find ways and means to facilitate his surreptitious return to the Philippines in order to free him from this court's jurisdiction. The news source of this letter petition is the online news portal of Business Mirror, and the news article is entitled, quote, Duterte supporters rally at Supreme Court, present 160,000 plus signatures for quick resolution of habeas corpus petitions dated 23 February 2026. The third recent development relevant to the issue at hand is the fact that on 6 January 2026, 3 children of Mr. Duterte filed separate submissions urging the Philippine Supreme Court to issue a decision calling for the release of their father from detention. One Duterte son, Congressman Paulo Duterte, has insisted that the Philippine Supreme Court should declare that the arrest, detention, surrender, and extradition of Mr. Duterte are unconstitutional and violative of international law. Congressman Duterte has reiterated his request for the Philippines' highest court to issue an order in support of the release of his father and prohibiting the Philippine government from cooperating with the ICC. The news source about this action of Mr. Duterte's children is
Excuse me,
found
Counsel.
in the online news portal of
Can the French booth please turn on the microphone? Thank you.
The news source about this action of Mr. Duterte's children is found in the online news portal GMA News Online, and the news article is entitled, quote, Duterte Kids Tell S Supreme Court Petition for Father's ICC Release Not Moot, unquote, dated 6 January 2026. We will forego arguing the statutory basis of our position and contentions, Your Honor. Thank you, Your Honor. May I continue, Your Honor, because there was a misunderstanding on the...
Oui, vous pouvez continuer. You can
Thank you,
continue.
Honor.
Counsel Andres.
We further wish to point out, Your Honors, that the conditions set forth in Article 58, subparagraph 1 of the Rome Statute continue to be met, and there has been no change of circumstances within the meaning of Article 60, subparagraph 3 of the statute or Rule 118, subparagraph 2 of the Rules of Procedure and Evidence that would support and justify Mr. Duterte's release from detention. On the contrary, as we have shown earlier, the new developments support his continued detention. In fact, we wish to emphasize that the prior findings that supported Mr. Duterte's continued detention remain valid and undisturbed, particularly in light of the fact that the confirmation of charges hearing has been held. There are no new facts that have emerged that would undermine the legal or factual findings in this chamber's last decision on detention. There is absolutely no basis for modifying the earlier ruling. Your Honors, the purpose of periodic review under Article 60, subparagraph 3, is to assess whether the conditions under Article 58, subparagraph 1, as required by Article 60, subparagraph 2, continue to be satisfied. As the Appeals Chamber has made clear, this review is not limited to newly submitted material. Rather, it requires the Chamber to consider the totality of these current circumstances to satisfy itself that continued detention remains necessary. In this case, the conditions under Article 58, subparagraph 1, A and B, remain firmly in place. We wish to emphasize that the Appeals Chamber has recently reiterated that pretrial chambers are authorized to assess the likelihood of future events. The question before this chamber is not whether interference is inevitable, but whether there exists a real possibility of such occurrences. On the present record, that possibility remains very strong. We wish to reiterate that there has been no material change in circumstances that support the entitlement of Mr. Duterte to an order releasing him from detention. On the contrary, the current procedural posture heightens the risk of non-appearance. As the proceedings advance, the suspect's incentive to flee increases. The end of the confirmation of charges hearing, which occurred today, further intensifies that risk, as it brings the prospects of trial nearer on the horizon. Additionally, the conclusions of the panel of experts that Mr. Duterte is able to follow the proceedings underscore rather than diminish the risk. His capacity to understand and participate necessarily implies a capacity to assess his situation and act upon it including the possibility of absconding. It must also be recalled that the appeals chamber has also found no error in the chamber's previous determination that Mr. Duterte has demonstrated a propensity to interfere with investigations. That assessment remains unchallenged by any new evidence. No intervening developments have displaced it. Moreover, Your Honors, this chamber found and the appeal chamber affirmed that Mr. Duterte benefits from a network of supporters capable of facilitating his flight. The existence and nature of such a network are not circumstances that are easily altered. No information has been presented that would suggest the support structure has dissipated or disappeared. Consequently, the risk of flight remains very substantial. With respect to Article 60, subparagraph 4, the chamber must consider whether the overall period of pretrial detention has become unreasonable, and if so, whether any delay is attributable to the prosecutor. Mr. Duterte has been detained since March 2025. However, given the gravity, the complexity, and the wide scope of the charges, the duration of detention is not unreasonable. Furthermore, there has been no inexcusable delay attributable to the prosecutor. The record does not support such an assertion. Finally, Your Honors, the position of victims and witnesses is a highly relevant and a significant consideration in this regard. The information provided to us by victims has always been consistent. They express genuine fears for their safety and that of their families should Mr. Duterte be released. The victims have articulated concerns about renewed instability and intimidation in their communities, particularly because of the holding of the confirmation of charges hearings. Therefore, we cannot stress enough the duty of the chamber to not only safeguard the rights of the suspect, but also to ensure the integrity of the proceedings and the protection of victims and witnesses. On the present record, releasing Mr. Duterte would create risks that the statute seeks expressly to prevent. Madam President, Your Honors, in light of the absence of any changes in circumstances that supports Mr. Duterte's release from detention, the continued existence of a significant risk of flight and interference, the advanced stage of the proceedings, the reasonable duration of detention to date, and the expressed concerns of victims, the participating victims respectfully submit that Mr. Duterte's continued pretrial detention remains both warranted and necessary. Thank you, Your Honors.
Merci beaucoup, Maître Bataillon. Nous pouvons désormais passer aux observations de la défense. Maître Kaufmann, vous avez jusqu'à 15 heures. Maintenant plus, parce que on est décalé.
Okay. As Your Honours are aware, the defence has appealed the pretrial chamber's decision on the first detention review. That's number 357 in the case record. And since we are still awaiting a judgment of the appeals chamber, the defence will not oppose the continuation of Mr. Duterte's current detention. Thank you.
Merci beaucoup, Maître Kaufmann. Donc, c'est toujours 15 heures. Ainsi se conclut l'audience. Les observations faites par les parties et par les participants seront prises en compte dans le cadre de la décision à revenir relative à l'examen périodique de la détention de M. Duterte, qui sera rendu par la Chambre compétente conformément à l'article 60, paragraphe 3 du Statut de Rome, dans les délais impartis à la règle 118, paragraphe 2 du règlement de procédure et de preuve. Je remercie une nouvelle fois les participants ainsi que les interprètes, le greffe, le personnel technique et à tous ceux qui ont contribué au bon déroulement de cette audience. L'audience est levée.
All rise, veuillez vous lever.